Okay, so for today, we're gonna discuss discovery, the rule of law called discovery, and what is it, ano nga ba yon, and why is it important. Okay? So here, sabi dito, discovery includes gaining access to witnesses, documents, records, and other types of evidence. So in short, discovery is any evidence. Pwedeng tao, pwedeng documents, pwedeng email, as long it can be as long as it can serve as an evidence. Okay. Now, why is it important? So let's read this first before I explain it to you. Sabi dito, attempts to protect witnesses and parties from undue harassment and to safeguard confidential material from being disclosed. Okay? Now, for example, nagnakaw ako ng 1 million pesos sa kumpanya. Diba? Tapos, itong kumpanya, syempre sinuwa ko. Hindi nila pwedeng, kunin yung bank record ko basta-basta at ipakita sa trial. Magugulat lang ako, sabi ko, saan mo nakuha yung bank account records ko? That's data privacy. So in short, discovery now, this allows me to, that this discovery allows me to protect myself from confidential material from being disclosed. Hindi ako pwedeng magulat dun sa korte, ba't ka may copy ng bank record ko? Bawal yan, data privacy yan. So it attempts to protect me. Okay? So in short, somehow, as a defendant, it's a defendant, medyo pro sa akin yon. Pero pag ikaw yung prosecutor and you want to gain evidence or want to gain documents from me, okay, medyo mahirap yung proseso nun. Actually, what some people do, ganito yung ginagawa nila. Okay? So for example, may kaso ako yung defendant. Okay, sabihin natin, they want now to gain a copy of my email records, okay? Email records about my conversations with the company. Kasi nga kinasuhan ako na kumuha ako ng 1 million. Okay, so they would request now a court for a discovery that I will show access to my emails, okay, that only pertains to my conversations with the company. Now, ito yung ginagawa nilang trick. I won't say kalokohan, pero as a defendant, kung gusto kong pahirapan yung prosecutor, mag-produce ako ng maraming papeles about my email communications at doon, sa sobrang daming papeles, pabibigay ko sa kanila at bahala silang magbasa, hanapin lahat-lahat yun. That is one type of, I won't say trick, not trick, but rather a strategy kung saan, okay, gusto tong documents ko, bigay ko sa inyo lahat. Sige, magpakahirap kayong maghanap, mag-scrutinize ng documents. So that is one strategy of what some lawyers do. Okay? So in short, as a defendant, di ba, parang, okay, that's a good one because I'm protected, pero as a prosecutor, medyo mahirap yan. Now, in that sense, that being said, okay, a court can deny and request the limit of the scope of discovery. So pag sinabing ganito, okay, the prosecutor wants a copy of all my email records, okay, email communications with the company. Ang dami kong binigay na papeles. What they can request is from the court is this limit the scope of discovery pertaining only to financial transactions. Kanina, sabi natin, ang gusto ng prosecutor is email transactions with the company. But you can limit it and ask the court, email transactions with the company pertaining only to financial transactions. Pero court yung mag-a-allow or magdi-deny nun. Okay? So, bakit yung court or mag-a-allow or magdi-deny yon? Because discovery now prevents surprises at trial by giving both parties access to evidence that otherwise might be hidden. Okay? So, sabi ko kanina, parang okay, kaya tayo may discovery, I would know now as a defendant, okay, they have this evidence, I know now how to defend myself. Hindi ako magugulat na, bakit ka may copy ng bank account ko? But the trial, I'm now ready. Okay, now that you have my bank account, which you ask permission from the court, I am now ready to defend myself. Okay? So yun yung purpose ng discovery. And of course, the litigants now can learn as much as they want to expect about the trial before they reach the courtroom. So balikan natin yung 1 million pesos na ninakaw ko kung wari from the company. Now they have access to my records. Okay, sasabihin nila, okay, ito yung kinuha mo nung 1 million pesos sa company. Okay, dated blah 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 blah. Now with that, I could defend myself. Okay, yung 1 million pesos, hindi po yan nanggaling sa company, nanggaling po yan dito. Okay? Pamana po yan or from my project and so on. So with that, sabi ko kanina, with the discovery, it allows me to be ready to defend myself with the type of evidence that the prosecutor has. Okay? So kuha yun. Alright, so babalik ngayon tayo dito. What are the types of discovery requests? So number one, okay, of course, the request for documents, madali na yan intindihan. If they want to gain access, for example, kung wari ang tawag dito, ang issue is land ownership, then they could request now for the title of the land, okay, because that is not in or their possession. So madali lang yan. Of course, electronic discovery, sabi natin for example, yung email kanina. Okay? Alright. Depositions. Now, if you're watching some law shows, for example, Suits, deposition now is you have the attorney, and then you have the client, and then the other party, you have the attorney, and then the client. Dito, magdidirektang tanong ngayon si attorney kay client. Okay? So here, before they go to trial, the person disposed gives testimony and answers questions asked by the attorneys from both sides. Itong recorded deposition now, okay, will give now both parties the opportunity to evaluate how their witnesses will conduct themselves at trial. Okay? Now, depositions now can be employed in a court to impeach or challenge the credibility of a party, of a witness who changes testimony at the trial. So for example, ako yung client, dinispose ako, video recorded interview, and then during the trial, hindi nagmamatch yung sinabi ko sa deposition at sa trial, then I could not be a credible witness in that sense, okay? Or a person for that, for that issue, okay? Or for that case. So, yun ang tinatawag na depositions. Titignan ko lang muna para siyang, let's say, job in, ang ano niyan, bago tayo pumunta sa trial, meron munang konting interview or ang analogy niyan, but the for analogy is, bago ka ma-hire sa job or bago ka pumunta sa trial, may job interview muna. Okay, makilala kita, ano ba muna ang case mo, what's your history, and then from that, as an attorney, I could now prepare my case against that person. Yun yung ginagawa ng deposition. Next is interrogations. So, interrogations are written questions for which written answers are prepared. So, anong difference niya sa deposition kanina and ang interrogation? So, number one, deposition is verbal, live na nagko-conduct ng interview. Interrogation is written. Now here, okay, the main difference of interrogations and written depositions is that the party answers the question and not the witness. Okay? So, depositions now are useful for eliciting candid responses from a certain party. Kasi sa interrogation, dahil written siya, okay, pwede kong paghandaan yung isasagot ko. However, deposition, dahil verbal siya o recorded interview, hindi ko pwedeng paghandaan yung sagot ko kasi nga para siyang live recorded interview. Okay? So, yun. So, sabi dito, interrogations are designed to obtain accurate information about specific topics, such as, for example, how many contracts were signed and when. Okay? Oh, and this is good. Request for examinations. I'm gonna read it first and then I'll explain. So when the physical or mental condition of one party is in question, the opposing party can ask the court to order a physical or mental information. Okay? So, for example, itong witness, bakit parang iba-iba yung sagot niya, hindi siya credible, and then I want to order na, okay, I want to disqualify your witness. Number one, okay, iba yung sagot niya, iba yung mentality niya. I want to order now a mental or physical examination of that witness. And then I could use that against my, against the opposing party. Okay? So, pag na-prove na examination yon na ay may mental condition siya, okay, then this cannot be a reliable witness. Okay? So, that is what you call a request for examinations. Okay? Kasi nga, di ba, when, say for example, bakit to nire-request yung mental or physical examination, sabihin natin for example yung mental examination, okay? If that witness somehow has a special disability, sometimes the person or the parents or the relatives do not want to disclose that, okay? For, of course, personal reasons. But then, in the court, I can request for that examination. Okay? So this information can be granted if the information required outweighs a person's right of privacy. Okay? Diba? Ulitin natin ha. This information can be granted if the information required outweighs the person's right of privacy. So doon babalik yung previous slide natin. Diba? Ang sabi dito, ayan o, attempts to protect witnesses and parties from undue harassment. Okay? Kaya tayo pwede mag-request for examination form from the court. Kailangan natin pong i-request yun. Alright, so with that, that's the end. So hopefully I'll see you next time. So please don't forget to like, share, and subscribe.